Okay, when I file a different motion, am I able to see a different judge since you don't want to talk to me and you don't want to explain to me and you're not patient enough and you're mad that I'm upset? You was literally just sitting here arguing with two different lawyers. They was loud. You didn't say anything.
I'm gonna tell you right now.
But now that I'm loud, you upset?
My patience. I've been more than patient with you. I've been more than
No, ma'am, you're not. Because you're not even helping me understand what's going on. You literally, last time I was in your courtroom, this is what you told me to do.
Well, you have not.
I'm confused.
There is courtroom structure.
I'm not yelling, but it just don't make sense. Okay, what you're saying to me don't make sense. You literally told me to do this last time I was in your courtroom, and I did it.
So I muted you because you're being irrational on the Zoom call.
Yep. Okay. Go. Will you hand me my screen box? Now go. Freak.
Yes, 1031, the Loyalty Apartment Flats versus Kia Stevenson. And this is on Miss Stevenson's motion. And you are Miss Stevenson, correct?
Correct.
If you'll raise your right hand. Do you swear or affirm the testimony provided today to be the truth, the whole truth, and nothing but the truth? So I'll help you?
Yes, ma'am.
Okay. So you are requesting the court to seal or remove the eviction on the basis that you are not fully aware that this was resulting in being made public records, creating a hardship
To secure housing.
securing housing despite matter being fully resolved. So let me see.
And Your Honor, Michelle Ron for the plaintiff for the Louis Flats for that CS 131. And we do object, as there is no way under Kentucky law right now to seal an eviction record.
Right. And so again, and I started to get into that with the other ones that were agreed orders to seal and vacate, that I usually say I'll do it and see if it sticks. I mean, I'll sign the order, but it doesn't actually, I haven't seen it be effectuated.
Right, but we object to it. Our client does not want it sealed.
Then what is then since you're objecting, what is your client's reasoning?
The eviction was filed, Your Honor, that the fact that she didn't understand it was going to be public record is not here nor there. It was an accurate eviction that was filed. And
I know, it was dismissed. So even with the dismissal.
I understand, but it was filed for a valid reason.
Mm-hmm.
They want it to stay in the record so that other landlords, when they do checks and everything, will know that an eviction was filed.
Yes, Miss Stevenson.
I want to go ahead and say that they ended up charging me for a month that I was not there.
We're not getting into that.
Okay, but she's saying that they won't they don't want to seal it or delete it. Y'all making me
can't delete it anyway.
They making me look bad when in reality I'm a great tenant. It was a misunderstanding on their behalf, which is why I'm asking them to remove it.
Well, the terminology is still, we don't remove it. Then you may recall this, Ms. Ron, under what circumstances was it dismissed?
I do not know, Your Honor. I don't have the file in front of me.
It was dismissed because I paid $2,000 plus, even with interest, through Genesis.
What's Genesis?
Whomever they used to come to collect for the month-to-month fee that they was charging.
Okay. All right. So what they're saying is what they have relayed to me through their attorney is without an agreement, usually a motion to seal, is one, I still questioning how effective those are, and we don't have legislative action that's really told me. And so there's a concern, that's been throughout the legal community about this very thing.
Right.
If it gets dismissed, should it continue to prejudice the party? Right now, in and of itself, there is not anything statutorily that's there that says it should then kind of like expungements.
Right.
It should be automatically removed in 60 days. I do think there are parties in our community that are advocating for that.
Mm-hmm.
Me personally, I think that's probably what I would like to see get done, but I'm in the judicial branch.
Right.
I'm not in the legislative branch trying to advocate for that. It's just not my role. And so while I am sympathetic to your situation with a valid objection, I have to deny it. Okay. So I'm denying your motion, because they don't have to agree. And for purposes of the court record, that's just unfortunate.
And Your Honor, just for the record, per the notes in our system, it was dismissed because she vacated.
No,
Was the
okay.
email we received from our client said to dismiss it the day because she had vacated prior to the eviction court date.
Okay, and not to say that you didn't make them whole later by paying everything, which is a good, thing to do, so you don't have that stigma. But just continue to try to advocate for yourself, and but that was a good, update for the court. Okay, all right. So good luck with everything.
Can I put her name down?
Yeah,
Can
she's
you
just
ask her to say her name?
it's Michelle Ron. Last name is RAWN, and she is an attorney.
And who she work for?
Well, here she represented the CS 1030. It's on the top of it. It's on the top.
I know she's representing the case, but I'm asking what company does she work for?
She works for her own law firm.
Her own law firm, so it's up under her name.
It's
Yes.
the Ron Law Firm.
It's the Ron Law Firm. And again, I understand. I just want to, as a judge and a former attorney, understand that they have to zealously advocate for their clients, and their clients are also giving them instructions and directive. And so she knows how to argue on their behalf for what her clients want.
Mhm.
All right. So I don't ever want you to come out of here thinking that an attorney themselves has something against you. They don't.
No, I don't too
Okay.
much care for what she has to say. I'm just
But-
going based off of what another lawyer had told me, that it is, I can come in here and request that it can be sealed or
Right.
removed.
And then if she had gotten a word from her client that they had no objection to it, there might have been something that could have been come together, but without an agreement, I'm just, I have to deny the motion, okay? And
Okay,
it's not her. Okay. Okay?
I get it.
All right. Thank you so much. Good luck with everything, Ms. Stevenson. Now, Mr. Zay and Mr. Maurer. This is on Joseph Holman versus Kevin Ford. I understand is legal guardian for Bertha Holman. What is going on in this case?
Judge, well, it's a forcible detainer action. And we raised the defense of lack of subject matter jurisdiction of the court at the beginning of the case. I think it was back in late March. I filed a short brief or memorandum in support of our motion. Mr. Moore filed a response late April. This is currently set for a jury trial on Tuesday, if I'm correct. And after reviewing everything in the case, I don't think we need the jury trial. I think this is resolved through this motion. And I wanted to put it before the court before we showed up for a jury trial and on Tuesday to see if it could be resolved today.
All right, Mr. Maurer. So this is a
Can we kind of lay the facts out real quick?
sure.
I've been living this case for a long time. So what happened was in 2017, Ms. Holman owned this particular house. She did a deed to her son and she deeded title to him, but she retained a life estate. Flash forward to, I think it was December of, I want to say Thanksgiving of 22. And up until that time, they both resided there together.
I'm listening.
In December of 22, she decided she didn't want to live in Louisville anymore. She wanted to go to Florida. So she went through a process of getting rid of everything in the house, either giving it away, selling it, whatever. And she packed up and moved to Florida. Greg was left in the house. The only thing that was left in the house was his bedroom furniture. It was pretty much empty. He refurnished it. And I think she moved in with it was a niece or somebody down in Florida. He's her only surviving child. And then importantly though, when she left for Florida in December of 22, she stopped paying all of the expenses associated with her use and occupancy of the house and abandoned the life estate. After, as I said, he then refurnished the house. And then in June of 23, she called him and said she wanted to return to Kentucky and asked if she could return and live at Tendor against advice of counsel. He allowed her to. And at that point, she became nothing more than a month-to-month tenant. In addition, when she returned to Tendor, the house, in June of 23, going forward, she paid only a few of the utilities at Tendor. She's paid no other expenses, including maintenance, and it's not in good condition. or wasn't. In the last 5 years, Greg has expended about $60,000 in repairs and maintenance on the property. He's paid the taxes. He paid the 23 and 24 property taxes and the required homeowners insurance for 23 and 24. She has not reimbursed him for any of those expenses. And indeed, this past March of 24, she was adjudicated fully disabled by a district court, this district court. And Mr. Ford was appointed as her full-time guardian. However, he also has not reimbursed my client for expenses he's paid or paid for any expenses since she's been there. And my client's understanding, and it's a verified response, my response to his motion is that based on her words and actions at the time, the move was permanent. She was relocating to Florida and abandoning her interest. Now, the law is, they keep saying this is a circuit court matter. It's not, because a lot of things can become district court forcible detainer actions. And I go through the law, but clearly it's almost a summary judgment issue as to her abandonment. Moving out of the house is not necessarily standing alone an abandonment of the life estate. However, when you combine moving out of the house with the fact that she has refused and or failed, whatever the reason is, to pay for there's case law that I cite, a life estate is not a free lunch or a free lunch ticket. You got to pay the expenses that go along with the use and occupancy of the property. And she's failed to do that. That part is an abandonment of the life estate. And particularly when you combine it with the fact that she moved, sold everything or gave everything away out of the house and left, that's part and parcel of the quote abandonment. So indeed, she has abandoned the life estate. At that point, she becomes nothing more than a holdover tenant. She has no different status than a trespasser or a squatter or a tenant whose lease is expired. And once you give them that notice, they got to leave. And 383-210 creates a statutory cause of action for a person aggrieved by a forcible entry or detainer. And that's exactly what this is. Clearly, this court has jurisdiction over this, unquestionably.
All right, Mr. Zay.
Yes. Well, Judge, plaintiff's making the assertion that the life estate's been abandoned. We dispute that. That is a legal question, I believe. However, this court cannot make that determination. A life estate is a freehold interest in real estate. And so this court may adjudicate the rest of the issues as far as forcible detainer goes, but this court cannot make the preliminary determination as to whether or not she has abandoned the life estate under the law.
I disagree, Judge.
Well, okay, go ahead.
He says
Well,
there's.
let me make sure he was ready.
Sure.
Let me make sure.
Sure. So our position is, Mr. Moore is saying today that the life estate's been abandoned. We disagree. This court doesn't have subject matter jurisdiction to make that determination. We need an order from circuit court saying she has abandoned the life estate under the law and the facts as applied to the law. And then if that order is entered, then we're in forcible court. But this court lacks the subject matter jurisdiction to rule on the threshold issue here, which is whether or not she has abandoned the life estate. And I'll just, to sum up, I mean, as a general rule of thumb, if your name is literally on the deed, it's a circuit court matter. That's just how I look at it, and that's how the law reads every time I look into this.
That is not the law of the common judge. And again, this would be real easy if she had paid those expenses and not abandoned the life estate.
But
where's the proof?
is your only argument that she abandoned it because she stopped paying?
Both. She left and she stopped paying.
And then she came back and allowed her, and he allowed her to continue to
as a month-to-month tenant, which is what she is.
But was the understanding that she was a month-to-month tenant? And
sure. Yes.
Well, where is your?
It's in he signed this. He signed this under oath. Verified this under oath. It was his understanding from her words and actions. Yeah, my client signed my verified memorandum in opposition to motion to dismiss. He said under oath that her words and actions were that she was abandoning the life estate and going to Florida to live with another relative. Then she changed her mind and wanted to come back, but he did not agree that she could come back in the capacity as a life tenant. And even if she did, there's still an abandonment because she didn't pay expenses.
That's the thing. I feel like it is a factual issue. I think it remains as a factual issue whether or not there's true abandonment of the life estate. Yeah, and if it is still a factual dispute, which
I still think that this court has jurisdiction over the matter, Judge.
if there's a factual dispute between whether or not the life estate was ended
Yes.
in district
Because,
court.
yes, because it's in connection with the determination that at that point she's a life tenant or a holdover tenant.
But I'm not making that determination. So I would still have to make that determination to get to the eviction. And so that was still at the first prong, I would say.
I see what the court's saying, but I still think this court has jurisdiction. Not to mention it, they disputed, but how? They just can't come into a court and say, well, we dispute that. How do you dispute that? If my allegation is she didn't pay expenses, where's the proof that she did?
Because I'm gonna tell you that because I haven't established whether or not something is a life estate, I don't know how circuit court rules on that. I don't know. I haven't done it, you know? I assume you two have, maybe.
And
And
the
I would
reason
think
why
it's
we mentioned
because-
Judge Leibson is we had a case very similar to this that she
Yeah.
adjudicated and determined that she had jurisdiction.
Okay, and I remember reaching out to her, and again, I tried to reach out to her again, but my concern is again, I haven't seen us adjudicate a life estate case in district court. Not saying that that makes it completely wrong or right. I don't have personal knowledge of that. I haven't done it, and from what I'm reading, I don't know if there was enough dissimilarities in that case that Judge Leibson felt comfortable going forward with it. And maybe, and if it wasn't appealed or anything like that, how it stuck.
I get it.
But the court today is not willing to make that, I can't make a ruling on that, which I do not know. But as far as there being a factual issue about whether or not the life estate was in fact terminated, and that being in the jurisdiction of circuit court, based on my understanding and based on the statutes, and again, if I'm wrong, they'll come back to me and I'll learn. That's all I can do,
I get it.
you know?
So we're not having trial Tuesday.
So there's no trial on Tuesday. And trying to think of the right order here. Grant defendant's motion to dismiss for lack of subject matter jurisdiction. And then I'll sign this and it'll be scanned into the file.
Okay.
And then again, we'll see where we go from there. I always love to learn. Let me know how it goes out. How it
Thanks,
turns
Judge.
out, Mr. Maurer, Mr. Zach. All right, thank you.
Judge.
Next, we have Steven Snyder versus Kenneth Booker. All right, so my understanding, gentlemen, this is on for Mr. Snyder's motion, Mr. Steven Snyder's motion that you guys had reached a small claim settlement agreement back on January 14th of 2024, and your assertion that he is no longer obliged by that agreement. Is that correct?
Yes,
All right, so you need to start with that. This is your order. You don't get an additional order from the court.
I don't understand.
Did you look in your small claims booklet?
Sure.
Okay. So you already have the judgment and order from the court.
Yes.
So,
I don't have a judgment from the court.
well, you have an order. You have
I'd like a judgment, please. Because I want to garnish his wage.
You still use the small claims agreement, settlement agreement order.
Yes.
So that's what you use.
Yes, that's what we used. The small claims agreement.
That's what you use, but now go forth and try to. Okay, so let me ask you this. Let me both you raise your right hand. Because I was wondering why this was on my docket, because technically your order is a binding order that you already received.
You know, when we were here, I asked this question of you, and
Sure.
you told me that the court clerks were going to help me with this.
I did not, first of all, you didn't hear that from me.
Well, that's the impression that I got.
Well, then let's correct that for the record, because I would not tell you that
Yeah.
clerks, let me finish. Clerks do not give legal advice. I would not in any way tell you that clerks will give you legal advice. I would refer you to the small claims settlement book. And I know I don't use that type of language because I would not put more obligation on the clerks than they are obligated to do.
Yeah.
So first of all, and then you said you were before the court before.
Mhm.
You weren't before me.
Yes, I'm before you.
You came before me with this.
I don't know.
Yeah.
Aren't you the judge that originally took our agreement,
That was Judge Moore,
Judge Moore.
Judge Jessica Moore.
You're not the judge that
No.
originally took our agreement.
No, sir.
Well, she did tell me that the people down there would help. They won't give me legal advice, but they could tell me which form to fill out. So I called my lawyer, and my lawyer told me just to enter a motion and talk to you at motion hour.
Okay.
And so I'm here, and Kenneth hasn't paid me, and
Okay.
I'd like a judgment, but you say that I already have a judgment.
You have this matter, which you need to then, because I went and I did talk with Chief Moore about this.
Chief Moore?
Judge Moore.
Okay.
That's who entered that. Let me step in. I'll grab it. Okay. One moment. Stay right here. I'm gonna go get my small claims settlement book, which you should have.
Is there any reason you haven't paid me?
I think everything up with that information here, I got my receipt.
Let's see.
And we'll get that judgment. Yeah.
Who'd you pay? The court?
Yeah.
Interesting. If you pay, she doesn't need to be doing all of this.
I paid every month except this month right here. Paid. This will be the third payment. I paid two of them.
They didn't give me any money. They didn't send me anything. So they
I made one today.
So you came down to the counter, paid me at the counter.
My paperwork. So I don't know. Wait for my time.
Let's see what you got. It's okay. I'm not gonna run off with it.
Two receipts.
That's okay.
I think I made one today. You see one receipt right there?
Today, what's the first one?
That's 300. I didn't have to pay for any of this was made.
Well, the first payment you made was on 5/15.
Okay, that's. They don't want my paperwork. Let me get to this and this.
All right. So I already put you under oath. And again, I have not had this matter coming for me. Let me just ask you this. As far as the small claim settlement agreement, you were to pay the plaintiff, Mr. Snyder, $2,500. And that was on the first of each month, beginning on March 1st of 2025 until paid in full. And normally, if a breach of this agreement, if the terms of this agreement are not complied with, then the entire amount plus the legal rate of interest will become due immediately. And you understand that to be the agreement that you reached with Mr. Snyder, sir?
Yes, ma'am. But I have made 2 payments.
Okay.
I've been going through some more time,
Yes, sir.
but I have made 2 payments. This month will be the 3rd payment that's due to him. So I haven't made that one.
So you haven't made May?
No.
Okay. Okay.
The
Go ahead.
the payments that he had, the first payment that he's asked for dates. Please. The first payment he made was 5/15.
$515?
No. May the 15th.
Okay, how much? But again, I
I
didn't do
don't
this.
know. I haven't gotten a payment. I haven't seen any money from this. He was supposed to start paying March the 1st.
I got you, but I also see how much was we supposed to pay
2,500. Oh, how much was he supposed to pay?
a month?
No, that was a typo. We were talking about 150. We had a verbal agreement for 150, but it wasn't entered.
Okay,
He didn't pay anything.
right. Well, sir, where are you sending payments to?
Out downstairs. I admit that I was late. I was
Downstairs.
I mean, not
Yeah.
downstairs, down here on the.
Into the court.
Yes, ma'am. I had the receipts.
Do you have any way to check? Because again, they're delayed when they're done that way, but
Yeah.
let me see what you make.
Well,
You can
I
hand it
made
to him.
one today.
You can hand it to that deputy and he'll hand it to me. I appreciate you, sir. Okay, May 23rd and May 15th. Do you have any other payments besides these 2?
No, ma'am.
Okay,
I would only be doing one more payment to be called up technically.
I understand what you're saying. I understand, But you all, again, so the only one that we technically have on the record does not state how much he was supposed to be paying, just that he would, on the first, he would,
1st of March.
on the first of each month, beginning April 1st. So one, I do, maybe in our haste, sometimes there's a lot going on in small claims. And then, but you guys have both told me your oral agreements was to pay, how was to pay? $150 a month.
Yes, ma'am.
But what it does say in the small claim settlement agreement is that it was supposed to be paid on the first, and you brought in proof that you haven't been doing that. So by virtue of the agreement that you did reach, you are in breach of the small claim settlement agreement. I did not get a clear answer, so I'm gonna cover my bases here and go ahead and find out if you actually, because I don't, again, a lot of times they would tender, let me see. Notice motion order. Where are you working, sir?
I work at a factory.
Because you can, you can agree to have, there can be, you can agree to have your wages garnished. You don't actually have to go through this way, but I have had that done before too. Because he's entitled to this. You guys made this agreement, but
So the total amount due was over $6,000.
you would not have gotten that in small claims?
I understand. I can't find a lawyer that'll do small collections for me. So I have to come to this venue.
I understand.
To take a $4,000 hit. But I've known Kenneth for a long time. I know how Kenneth does his finances.
Unfortunately, there's a lot of people that fall into hard times and they're not financially savvy and don't have various reasons and hardships. And I appreciate you trying to work with it. Well, because my understanding was, there's a small claims settlement agreement should be enough, for you to do that. And
to just go ahead and garnish?
it's an order of the court, but I also agree that it doesn't show that they've breached it. So I'll probably then, in my due diligence, what I'm talking about, make sure I attach the small claim settlement agreement that I find that has been breached. And then from there, you can,
come back to the clerk.
You'll have to understand how you want to go about if your goal is to garnish his wages, okay? And how to get that order. Because the clerk nor I can give you legal advice about how to do that, but if you ask for certain forms, they'll give them to you, okay?
Well, the lawyer that I have paid for the last 40 years, he gives me legal advice. But
He should.
He does, but it's kind of hard to follow it. But he won't do my collections for me.
It's not,
So if
listen.
collections job.
Nah, I understand what you're saying. So all I can do is I can tell you that, and just so you understand what's going on, Mr. Booker. So I have found that you are in breach of that small claim settlement agreement. I'm gonna try to either I'll issue an order stating such, and then that he is entitled to the full amount that is owed and due. Okay, so now he'll have a judgment. It's still, again, the onus is still on you to use that how you see fit to try to collect your judgment. But you owe it. You reached that agreement, you're in breach. Oh, let me see, I don't want to take the amount. I will deduct 150, I'll deduct 300 from the total 2685 that was agreed upon. That should have been with court costs, right? Yeah, there's court costs. You're entitled to court. So it was 2,500 plus 185.50 for court costs. I'm gonna deduct 300 from that because it's in the court system and they have to mail it to you.
So initially we sent there were two sheriff's visits. Initially the sheriff, we couldn't get it served. And then we had to file it as home address.
Sure.
Did I get credit for both?
I won't go back on that though. I won't go back on what it says is immediate. This is always, as terms of this agreement, I comply with the entire amount is due in full. Okay, so I understand. So I'm going to start with so you'll owe $2,385.50. I just subtracted the 300.
Okay.
All right, good luck with everything. Thank you so much.
All right, thank you.
All right. This is First Franklin Financial Corporation versus Sandra O'Brien.
Afternoon, Your Honor.
Good afternoon. Oh, yes, I'm sorry, this is one, yeah, come on up.
Thank you. Judge, Miss O'Brien is here with me.
She needs to come up, come on.
If you will approach.
Everybody come up.
Judge, here's my understanding. Miss O'Brien made this motion on her own and
Hold on, is Mr. Jacob Mills, are you here on this case?
Yes, Your Honor. I'm standing in on behalf of plaintiff's counsel.
All right, let's get everybody's on the record. All right, and this is on for Miss O'Brien's motion to set aside the garnishment?
yes, Judge, here's my understanding of what happened.
Okay.
There was a suit was filed against my client. Frankly, at that time, the debt was due and owing. My client agreed that the debt was due and owing. She and Mr. Clark entered into an agreement. My understanding is that my client signed the agreement, Mr. Clark signed the agreement, and there should be an agreement in the file. So I don't know if that's in fact what happened, but that's what my client says happened, and I have reason to believe that Ms. O'Brien is very cognizant of what went on.
Mr. Mills, do you know if there was a tendered agreed?
Yes, Your Honor. There was an agreed judgment entered in this matter, Your Honor, back in it was March 11th, that indicated that payments were to be made on the 15th day of each month, and that if there were any late payments, we could the entire debt would be due and owing. And we, as part of Exhibit B, had attached some text messages indicating that all the payments have been made have been late. And the
Go ahead, keep going, just so I recall this now, but go ahead.
Oh, yes, Your Honor. I just didn't want to talk over you. There were admissions from the other side indicating that these payments were late, and as part of the agreed judgment, it indicated that acceptance of a late payment is not a waiver to the terms of the agreement. So because the payments were made late, the entire balance is now due and owing, and the garnishment is proper.
Judge, my understanding is that my client made a payment in February for the correct amount, March for the correct amount, April for the correct amount.
She did.
All three payments were negotiated by the other side.
Yep.
And before the 15th, my understanding is that payments were due on the 15th, more or less. And that before the 15th, my client's bank account was then garnished and her wage was garnished. And we do not believe that that is appropriate, and that the garnishment should be set aside and the funds returned.
All right, but we don't have a garnishment order in this case either, by the way. I don't know where that is, but clearly it's in effect. If you could I put that on a note on here. When was the first garnishment made?
Judge, my client made a payment in February.
I already know that, and they were all late.
Okay.
So, but when was the first garnishment?
The first garnishment was received before the 15th of the month.
But what day, what month?
May. Garnishment was in May.
Yeah,
Judge.
In the May.
May the 4th.
Okay,
And the payment for April had been cashed.
right, but they're all, again, but at least the two
The
presented
first
to the
one was
court
not late. The second one was like 2 days,
late, 2 days late.
a couple of days late. Yeah.
They're both late. And only one late payment was all it would take for them to trigger their agreed upon right to then garnish her wages.
Judge, my concern is that were they late because they were delayed in the mail,
No.
or they were late because they were mailed late? If they're not mailed late, then I don't think they're late.
Unfortunately, plaintiff filed so plaintiff, counsel for plaintiff did file a response, and I did recall reviewing this yesterday. The exhibits are a text message from Miss O'Brien saying, I put it in the post office 5 minutes ago. That text was sent, let's say, on February 18th. She shows them, but again, that's 3 days after, and that's an admission. And then she has another one from March. She texts on March 17th saying, I'm putting it in the post office right now. I just got back from Bowling Green, checking on my sister. She's doing better. Hope she still is. And she's walking on her own now. Just want to let you know it's in the mail today. And thanks, Sandra O'Brien. Hope you have a good weekend. That was sent on March 17th. Notably, already 2 days passed, and so you just want to wait in the mail. Another time, her trying to do her due diligence, and I'm not saying that I hope we're hoping that maybe they'll just ignore it and say, okay, at least she's paying. Yeah. But they didn't, because this one on April 29th. Again, all for the right amount. It still says, sorry for the delay. It's been a crazy April. I'm sure May will be a little bit better. Hopefully, apologize. I will call and message you Thursday to make sure you got this now, and I will be sending May's out before the 15th. And again, so that one went out. So again, I did review that agreement, and it does, plaintiff filed a very succinct motion as well, an opposition, a response, I should say, not a motion, a response to her garnishment challenge, shouldn't use lingo, and referring very specifically to the agreed judgment that was entered by the parties on March 11th, that they can even cash it, they can accept it, but it is not going to take away their right to go for the judgment in full, and both parties agreed to that.
Judge, the only thing I would say is that my client, while being a few days late, did make the payment.
Yes,
and
sir.
perhaps felt like she could, for legitimate reasons, not make the payment late automatically. But if things came up and she made it late, she felt like that she had, if not permission, but at least there's an acquiescence on the part of the plaintiff. If the plaintiff wished to pull the rug out from under her, they should have done it the first time it was late. They didn't. And now she believes that, not that she deliberately makes it late, but she believes that there is some leeway with regard to when the payment's made. And that's what plaintiff led her to believe by, if you will, not garnishing her the very first time that it happened. So based upon a pattern and practice of the plaintiff, I would say to Your Honor that the garnishment should not be sustained.
Your Honor, if I may.
Yes, she may, Mr. Mills. Go ahead.
Thank you, Your Honor. We empathize with the defendant's circumstances, but plaintiff has strictly adhered to the terms of the agreed judgment. The terms could not be clearer. If there is a late payment, or if payment is not made by the date certain in the agreed judgment, then the entire balance is now due and owing, and any payment accepted is not considered a waiver on behalf of the plaintiff. I don't think it could be any clearer here as to the breach and the garnishment being effective.
Judge, let me just add a little bit of more equity to the situation. My client's son has recently been shot in the back 4 times. He is now paralyzed. Some of that money was for his wheelchair ramp that they were going to build and put their house on. And I'm asking the plaintiff to return that money so that she may build that ramp, and you can expect your payments each month. The individual, the plaintiff in this case, is hardly at the financial disadvantage that my client now finds herself in. And I think it would be appropriate, again, to just do the right thing. Take the payments, even though they're late.
Okay.
And I'm sure that the plaintiff has never made a late payment.
Again, this is not a matter where the court can, outside of legal grounds, hang her and, equitable, this is just the right thing to do hat. I'm not saying that is not the right thing to do, but I'm saying that there's a small claims judgment and they have every right to enforce it. If there are any ways of which you can work out new terms and then the garnishment can be stopped by an agreement, you would have to reach a new agreement.
Judge, can I inquire as to whether or not there's any money still due and owing on this debt? Mr. Mills, do you know?
Your Honor, you'll have to reach out to counsel of record on this. But my understanding is that it has not been satisfied in full. I don't have the exact figure on front of me.
Well, per the agreed judgment, the amount was $2,425.18. And she has made 3 or 4 payments.
February, March, and April. Correct
2,
amount.
4, 6, 8, right?
But they took $2,500 out of the bank.
Yeah, they took everything I had.
They garnished the entire amount?
Yes. Yes, ma'am. That's money that people donated
Where is
for
the
my
garnishment
son.
order? Oh, well, that's the thing. It's because the entire amount will be due and owing.
But the entire amount due and owing couldn't have been $2,500 because my client made 3 payments.
So then they're right, Mr. Mills. How much was taken from the garnishment and out of the garnishment? Where's the order? Order. Yeah, that's okay. It's not for you to know.
It was $2,541 they took out of my check. my
Well,
account.
do you have it? Do you have proof? Yeah, because then
Yeah.
you're also in breach of the
Well, I sent
agreement,
you a
Mr. Mills,
paper
because you
of it.
took more than that. You should been.
Yeah, my understanding, Your Honor, and I don't know what counsel of record has received, but having done collections and done these garnishment challenges before, typically when there's a garnishment challenge issued, those funds are then frozen by the bank, awaiting an order from the court to release. So I'm not sure if plaintiff's counsel or plaintiff has actually received any funds, and it may be that whatever is doing owing can be applied to that balance, and if there is anything left, then it would be left in that account, would not be distributed over to plaintiff or plaintiff's counsel. At least that's how it's worked in other cases that I've had in similar situations.
I do think that's how things work out, Judge. I do think that's appropriate as to how to do that.
Okay. And I don't have the garnishment order in front of me, so. I've learned, no fault of my clerks, but there is definitely a misunderstanding of that needing to be in the file for me to review.
Yeah, if the garnishment order was for $2,500, and that would have been for too much. So maybe we'll wait for the garnishment order to catch up with the file, put the matter back on the docket and try and resolve the math issue.
But even still, why would it have been for 2,500 if the amount, the highest amount they could have received was 24,2518?
And Your Honor, I don't have the garnishment in front of me. I do apologize. But I do see that the judgment was in for the principal balance of $2,425 and change, with a large post-judgment interest on there and attorney's fees and court costs.
Okay.
And was the 36% interest based on a written contract signed by my client?
I believe so.
I
Yes.
see that part. Was,
I believe that's statutorily compliant as well.
but yeah, so that makes more sense. I'm sorry. If I read the next sentence, I would have noticed that, Mr. Mills. Yeah, the 36% interest is on the, I do note that just for my due diligence. So again, with the interest, with the unpaid late fees plus attorney fees and the court costs. So they would have definitely put it into that realm of 2,500. So.
Judge, let me get with Mr. Clark, do some math,
Sure.
and perhaps come back with another motion if that's necessary.
Oh yeah, and you can either come back with a motion or you guys try to put some other agreed order before the court. But now that she has counsel, she understands the terms of the agreement, especially if there's strict compliance and such other outcomes should she not comply. I'm sure you'll advise her accordingly.
Yes, I will.
So for now, I'll note that the garnishment of the wage garnishment order presented. I'm still fine for the creditor that the wage garnishment remain in effect.
Right.
Okay. And it's Eden Apartments versus Kiana Williams. And Miss Williams is on Zoom. I need her to press *6 to unmute. Now I've prompted her. I'm sure Miss Lisa's prompted her. Kiana Williams.
Hello. Can you hear me?
I can hear you now.
I'm here. Can you hear me?
I can hear you. I can hear you.
Okay.
So, Miss Williams, you are present on your motion to dismiss the eviction because this case was filed after case number, and you gave me another number, had been case number 23C 937. This case had been dismissed. So I'm confused on what your motion is saying.
That's the wrong case. Oh my gosh.
That's okay, because I thought you were going to refer to it. So I have another case in the system that was yours. It is 23C 005805.
Yes, that is because I know it's a case. Because so they had filed two.
Miss Williams, real quick. Let me swear you in because you're giving testimony. I just need to swear you in. Raise your right hand. Let me know you've done so.
I did.
All right. You swear or affirm the testimony provided today to be the truth, the whole truth, and nothing but the truth, so help you?
Yes, ma'am.
Okay. Go ahead.
Yes. So I had just came here last month for you guys to dismiss the eviction that was filed. I don't know the file date was April the 15th. It's an eviction between the first eviction I ever got and the last eviction I got that was still on my record that we put another motion in to dismiss that one, the one that's in between the two. Because it's still sitting open on my record.
Do you have 3?
Yeah, she got 3 cases.
I had 3 only have been dismissed.
This one had, what happened with the middle one?
First one was there was an eviction granted.
2867, that one was an eviction judgment.
Order setting aside
For 2867?
for that case.
Okay. So we gotta set aside in the 24 eviction case.
Okay.
So
is set aside like the same thing as dismissed or?
So in 24, the case for 2024, that's the only one that been granted, and then there was legal paperwork of a filing to set aside and dismiss. So that was granted in that case.
Right, and then it was one before that one.
So this case, though, 23C 009371, where the eviction was ordered on August 21st of 2023, there is in the file there's nothing about an agreement to set aside the eviction and dismiss it.
You said it's nothing in the file to do that? What do you mean by that?
Okay.
Because this is the same property. So if the one
property is if the evictions are filed for different times.
Okay, but so do I need to bring in another document of when the landlord or the property manager signed the document like I provided last time, stating that she will work closely with the neighborhood police? She she signed and dated the document saying that she would not process any evictions or something like that. I don't remember the document exactly word from word, but I don't see how that eviction can stand when the eviction outside of that was dismissed. I did not move out of this apartment complex till literally April of 2024.
Williams, let me tell you, each eviction carries its own set of pleadings, transactions, and circumstances. Okay? So there's.
And then the lawyer literally said yesterday. Well, when I was in the
No, Miss Williams, please don't talk over me. Just let me finish, okay? Let me finish.
Oh my God!
Listen, so I can explain to you. So each case, if there is an eviction filed, it needs to then have there's either going to be a ruling by the judge of an eviction or a dismissal. Each case needs to have its own. If you and the property manager thought you had come to an agreement to set aside an eviction judgment that had been entered, then that property manager can get with their attorney and file the property.
The attorney literally told me last court date that they don't mind to set this one aside like they did the other one.
Ms. Williams, are you going to I'm not going to keep letting you yell.
Oh my God.
You yell at me. I'm just not. There is courtroom structure.
I'm not yelling, but it just don't make sense. Okay, what you're saying to me don't make sense. You literally told me to do this last time I was in your courtroom, and I did it.
So I muted you because you're being irrational on the Zoom call. I'm going to explain this one last time. I hope you're listening. The motion you presently put before the court to dismiss an eviction is denied. It is denied at this time. If you can get with the attorney, if you can get with the property manager to let them know that and you guys have an agreement to set aside the eviction on this case, ask them to contact their attorney and to file the proper legal pleading with the court. Until then, this case is an eviction judgment and your motion is denied. I hope you have a good day, Ms. Williams. All right. And I'm going to also remove you from the courtroom. Thank you so much.
So are you not going to allow me to talk?
No, you've already talked. There's nothing else to say. There's nothing else.
Ma'am, I was literally just in your last courtroom a month ago.
I muted you again because you're not going to tell me anything differently.
What you told me to do? Like, I'm confused.
You
And then you don't even want to explain to me. You keep saying I'm upset. I should be upset. Do you not know what these people are doing to me or have done to me? Like, I was trying to explain to you before you muted me. Just like this is the same scenario as it was when I came in your courtroom a month ago. I was literally just there on April the 24th. It's the same scenario. You dismissed it. And then the lawyer literally told me they don't mind to dismiss it again.
I muted you. I can't. So again, your motion is denied. Contact the attorney.
Okay, when I file a different motion, am I able to see a different judge since you don't want to talk to me and you don't want to explain to me and you're not patient enough and you're mad that I'm upset? You was literally just sitting here arguing with two different lawyers. They was loud. You didn't say anything.
I'm gonna tell you right now.
But now that I'm loud, you upset?
My patience. I've been more than patient with you. I've been more than.
No, ma'am, you're not. Because you're not even helping me understand what's going on. You literally, last time I was in your courtroom, this is what you told me to do.
Well, you have not.
I'm confused. You
have not done it. Go contact the property manager. Ask them to contact their attorney for an agreed order of a set aside. You don't have that in this case, ma'am.
I didn't have it in the last case, Judge, and you dismissed it.
You are excused. Have a good day. Okay.
Are you done with the eviction docket?
Well, can you give me a moment to breathe, Mr. Snow?
No, I just.
Can you give me 2
I have
seconds?
a question.
Give me 10 seconds.
I have a question.
Give me 10 seconds.
One,
let me write.
two,
Let me write on this one, and I'm gonna mute you. I'm muting you in the air right now. Good Lord.
Are you gonna put me in the jury box for timeout?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in first. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, I'm sitting up here, I'm the one that needs a drink.